All right, so let's get started. Today's topic is felony murder. If you recall, a little over 3 weeks ago, just before spring break, this is the conversation we were having before we ended class. And if you take a look at the first slide, just a few basic points to keep in your mind as we talk about felony murder. The first, that it is a traditional crime that existed at common law. It was one of the four types of murder with malice aforethought, right, based on intent to commit any felony. The second point to keep in mind is that it is strict liability with respect to the homicide, the killing, the death, right? The only mens rea or culpability that must be proven relates to the underlying felony, or what we call the predicate felony. No mens rea need be proven with respect to the death. So felony murder can attach regardless of whether the defendant acts intentionally, recklessly, negligently, accidentally, unforeseeably in causing death. The final point to keep in mind is that unlike most other strict liability crimes, particularly public welfare offenses, the punishment for felony murder is quite serious. All right, it can result in a life sentence or life without parole sentence. All right, even for what might be an accidental or an unintended killing. Next slide. So at the end of last class, we were talking about the Fuller case, which does two things. It sets out the basic elements or rules with respect to felony murder in California in particular, and then as well, it sets out a number of critiques, right? So recall, in this case, the defendants are alleged to have committed burglary, more particularly, right, entering a vehicle, the doors of the vehicle, which are locked, with the intent to commit larceny or any felony. And the facts here established each of those elements, and hence that the defendants committed burglary. After the defendants allegedly committed the burglary, right, law enforcement discovers them and follows them, and a getaway chase ensues. And during this getaway chase, the defendants run a red light in their vehicle and hit another vehicle, killing the driver of that vehicle. Right? So we can see here now that the defendants have committed a felony, burglary. A homicide occurred, that is a killing of one individual by another. Here, the defendants killed the driver of another vehicle. And so the question is whether or not the defendants were properly charged with felony murder under California's felony murder statute. And here, California Penal Code Section 189 declared that all murder which is committed in the perpetration of or attempt to perpetrate arson, rape, robbery, burglary, mayhem, or lewd acts with a minor is murder of the first degree. So the elements that have to be established are: 1, murder or killing; 2, that the death or the killing was in the perpetration of or attempt to perpetrate; 3, an enumerated felony, here burglary. Next slide. So here we see that California has enacted a modified felony murder rule, in the sense that at common law, commission of any felony could support first-degree murder. And here, under California's statute, California Penal Code Section 189, only certain enumerated felonies give rise to first-degree murder. Any other felonies that are not enumerated in the statute would give rise to second-degree felony murder. So the court concludes that the defendants can be charged with first-degree felony murder. Notwithstanding, the court reveals that it does not approve of felony murder charges, and the opinion provides 4 critiques of the felony murder rule. So one critique is that felony murder allows for disproportionality, right? In the words of the court, destruction of the, quote, symmetry of the law. In other words, a purely accidental death through no direct act of a defendant who committed a petty theft charge could be equated with a premeditated killing. Right, so imagine a scenario in which a merchant follows a shoplifter out of a store, and the merchant falls and hits his head and dies. The shoplifter could be charged with and held accountable for first-degree felony murder. Right, or imagine a scene in which a bank robber runs from the scene of a bank robbery carrying a gun, and a individual sees the bank robber and dies of fright. Or finally, imagine that an individual is hunting or cleaning a firearm and accidentally discharges the firearm, hitting and killing another individual, right? The felony might be reckless handling or misuse of a firearm, and a death results, and that individual could be charged with felony murder. Arguably, the conduct in these cases should not be equally punished as willful, premeditated, and deliberate homicide, right? Because there is a disparity in culpability, right? On the one hand, an individual who has acted willfully and with premeditation and deliberation is treated just the same as someone who has accidentally killed another individual or unintentionally killed another individual, all right? And that would seem disproportional. Another proportionality problem is if you assume that the doors of the van or the vehicle that the defendants in Fuller entered had been unlocked, then the defendants couldn't have been charged with felony murder, right? They would not have been guilty of burglary, an enumerated felony, and hence there would be no basis on which to charge them with first-degree felony murder, or in fact, probably any felony murder, because there would have been no felony committed, right? So if we notice, one small change in facts could have resulted in a very different outcome for the defendants, right? So it seems disproportional to equate their dangerousness or their culpability to first-degree murder based simply on the fact that the doors of the vehicle had been locked. All right, a second concern with respect to felony murder charges is that in some instances they may not be committed in a dangerous way, right? That the felony may be so-called non-dangerous, and hence we should not equate felony murder with acting willfully, premeditated, and with deliberation, right? So in this particular case, the burglary was done on a Saturday morning. No one was around. The defendants were not armed. They didn't seem to anticipate any use of violence. So arguably the burglary committed in this instance, the felony committed in this instance, was not dangerous, all right? So it seems unwise to punish the defendants as seriously as someone who committed a felony that did potentially create danger. All right, so the court in Fuller is not suggesting that burglary can never be committed with danger, right? But the burglary in this particular case seemed to be non-dangerous. A burglary that could be dangerous would be where a victim is present, or the defendant is committing the burglary and a victim comes upon the scene and that victim responds and the defendant responds violently, or maybe a carjacking. All right, so we should understand the court's criticism in Fuller to mean not that auto burglary is not dangerous or cannot be committed dangerously, and so therefore should not support felony murder, rather that burglary is not inherently dangerous. That is, there are situations where it might be dangerous and situations where it may not be. And those situations where it is not dangerous should not support felony murder charges. All right, think about it. The notion of felony murder or any particular criminal justice charge may be to deter individuals from committing the crime. And where an individual is not planning to commit a crime with any level of danger or violence or potential harm to other individuals or death to other individuals, right, you can't deter them by imposing a serious, harsh punishment such as that would be attached to felony murder, right? Because they weren't planning to engage in any violence. So you can't deter them from what they were not planning to do. All right, and so what we will see in future conversation is that some jurisdictions have adopted an inherently dangerous felony limitation on the application of the felony murder rule. In particular, when we talk about Howard in your reading, we'll see the application of this limitation. A third critique that comes from Fuller, and this is where we left off last class, is that we want to ensure that there is some connection between the underlying felony and the death, right? So because felony murder might attach when a defendant acts unintentionally or accidentally or without any foreseeability that the death will result, right? We have some concerns about whether or not there was a causal connection between the underlying conduct, the felony, and the death. Remember, it's a result crime, a homicide crime, and so we should expect to prove causation. So here, right, in Fuller, right, we might have some questions about whether or not the death of the driver of the other vehicle was committed, quote, in the perpetration of the burglary, right? Remember, the facts are that the defendants committed the burglary, they got the tires, they were done committing the offense, and as they were driving away, law enforcement comes upon them and a chase ensues, and it's during that getaway chase that the victim is killed, right? So it is possible that a court could have interpreted the phrase in the perpetration of in Fuller in a way that favored the defendants. In other words, that the conduct of killing the victim did not occur in the perpetration of the burglary, right? The burglary had already been completed. The defendants had completed the crime, and the killing was a separate course of conduct. In other words, there was no causal connection between the felony burglary and the death. This concern or this critique explains why and how some courts have sought to limit the harshness of felony murder by imposing a limit that felony murder applies only where the killing is committed in the perpetration of or in the furtherance of the felony. We see this in California's felony murder statute by inclusion of the language in the perpetration of. So a final critique, right, is that the felony murder rule is unnecessary. In other words, the government could have charged the defendant with some other form of homicide and possibly even murder, and it did not need the felony murder charge. So consider on your own time whether or not or how the government could have charged the defendants with depraved heart murder, which constitutes second-degree murder in California. And so it's possible that even without a felony murder charge, the defendants could have been convicted of the most serious form of homicide. And so it's unnecessary. Of course, what we know is that a prosecutor would certainly prefer not to have to prove mens rea and still obtain the most serious offensive conviction. Felony murder, hence, is easy or efficient for prosecutors. So the four critiques, again, in short, are that the application of felony murder can result in disproportional outcomes based on the lack of culpability or intention to cause a death or a small change in facts. Second, that the felony murder rule can apply in situations even where the underlying felony is not inherently dangerous, and so there's no need to deter defendants. In fact, you can't deter defendants from engaging in the conduct. Third, that the felony murder rule might apply at times where there is no causal connection between the felonious conduct and the death. And then finally, that the felony murder rule is unnecessary and is just an easy or efficient way to allow the government to charge defendants with a very serious crime. All right, so given that we now understand the basics of a felony murder charge and the quite common critiques of felony murder charges, we're going to spend some time looking at limitations on the harshness of the felony murder rule, right? Those three limitations include: one, the quote, in the perpetration of or in the furtherance of limitation that we saw in Fuller; two, the inherently dangerous requirement that was alluded to in Fuller, in which we discuss in Howard; And then 3, the independent felonious purpose or the merger requirement, which we'll also talk about. Keep in mind, because we are in Georgia, unlike many other jurisdictions, Georgia has not created any limitations on felony murder. So in the next slide, we discuss the Howard case, right? Remember, Fuller suggests that only those felonies that are inherently dangerous felonies should serve as a predicate or an underlying felony for a felony murder charge, right? And while California has adopted this limitation, it is quite a common limitation imposed in many other jurisdictions. Howard expands our understanding of that limit. So at the outset of part 2 of the opinion, the court notes that we're dealing with a second-degree judicially created felony murder charge, right? So again, the California homicide statute dictates that first-degree murder exists for a killing in the perpetration of an enumerated felony, and all other killings in the perpetration of a felony constitute second-degree murder. All right, so non-enumerated felonies can support a second-degree felony murder charge, but as we see in the Howard case, those felonies must be inherently dangerous felonies. This is a judge-made rule, a rule coming out of judicial opinions, right? And judges have authority to constrain or expand the understanding of a rule, as we discussed way back in the beginning of the semester, right? And they can do so without infringing on legislative authority or function to create crimes. Remember that legality principle. All right, so here the court sets out a test for whether or not a felony is inherently dangerous and thus can support a second-degree felony murder charge. And the test looks to the elements of the felony in the abstract. So let me say that again. You look to whether or not the felony, by its nature, cannot be committed without the creation of the substantial risk that someone will be killed. All right, you do not look to the particular facts of the case or the defendant's particular conduct. You are looking at the abstract elements and determining whether or not the offense, the burglary, can be committed without the creation of a substantial risk that someone will be killed. Again, it is not a fact-specific or case-specific inquiry. It is an abstract theoretical analysis just looking at the statute. The opinion then goes on to identify some felonies that previously have been ruled inherently dangerous and some that have not. And you should be able to pull those out on your own. So, for example, flee to elude or fleeing or from law enforcement is not inherently dangerous, right? Child safety, basic child safety requirements are not inherently dangerous. And so the issue in this particular case is whether or not the offense of flee to elude, which could be a felony, is inherently dangerous. So, for example, the court concludes that it is not. And the rationale is that it can be committed without endangering human life, right? So you can flee to elude by committing minor traffic violations that pose no risk. And so here, think about O.J. Simpson's getaway chase after he had been accused of homicide, in particular the killing of his ex-wife and ex-wife's friend, right? That's a slow speed chase in which he could have committed 3 traffic violations. So driving too slow, what are called California stops, not fully stopping at a stop sign, going the wrong way on an empty road, driving without his lights, all right? If you're not familiar with this particular chase, then check it out online. But the point is that flee to elude, the court concludes, is not an inherently dangerous felony because it can be committed without endangering human life. On the other hand, it could be committed by endangering human life. You could have very serious traffic violations, right? Running a red light in a busy intersection, reckless driving, right? High speed getaway chase, right? All of those could be very serious traffic violations. So in the abstract, flee to elude is not inherently dangerous because it could be committed either by committing serious traffic offenses that endanger human life or by committing non-serious or minor traffic violations that do not endanger human life. So if there is any way in which the predicate felony can be committed without creating a substantial risk of death to someone, then it is not an inherently dangerous felony. So consider the legislature's unexpected role in this decision, right? What the legislature had done is expand the scope of the flee to elude charge to include a lot of relatively non-dangerous driving conduct, right? The legislature perhaps inadvertently diluted it enough to take it out of the felony murder rule. That is the second-degree felony murder rule. If we look at some of the other justices' opinions, here Justice Brown would abrogate or completely eliminate the second-degree felony murder rule. He doesn't approve of it at all. Justice Baxter is concerned that the majority is elevating form over substance, all right, that by creating a separate provision, right, the legislature was not intending to prevent flee to elude from supporting a felony murder charge. And in fact, if the legislature had left the vehicle code unamended and created a separate provision that we could call, for example, fleeing a police officer in a way that results in 3 serious traffic violations, then it could have supported a second-degree felony murder charge. So why should we elevate form over substance? The mere fact that the legislature created one provision with 2 subparts, or over the fact that the legislature could have created 2 separate provisions? If you're struggling with that a little bit, put a note in the discussion forum and we can hash it out some more. Okay, so in the Howard case, we see this application of the inherently dangerous felony rule, right? Most jurisdictions have adopted a rule in which you looked at the abstract elements of the offense to determine whether or not it can be committed without substantial risk of death to another individual. And if the answer is yes, then it is not an inherently dangerous felony and cannot support a felony murder charge. There are some jurisdictions that look case specific, right? But the majority approach is an abstract theoretical analysis. So take a look at the next slide, which helps us begin to understand the the independent felony or the merger limitation. All right, again, Georgia does not have this merger limitation. Many other jurisdictions do, but a word of caution, which is that there's no single approach to this issue. Courts are remarkably confused and all over the place with respect to these opinions. But here's how you can understand the independent felony or the merger limitation in a basic sense. Consider the following. The defendant comes home and finds his spouse in the act of adultery. In a rage, the defendant stabs to death the spouse or the spouse's lover. If you recall, when we began our homicide discussions, we talked about heat of passion killings. So here, the defendant could be charged with a willful or intentional killing under common law or a heat of passion killing under common law. And if the defendant were charged with heat of passion, then that would be a manslaughter, right? We would mitigate the murder charge, the intentional killing, to manslaughter. But then you might ask, well, because the killing occurred during the commission of a felony, aggravated assault or assault, could the defendant be charged with felony murder? The answer in short is yes, in theory, but that seems inappropriate. Remember, when a spouse kills a spouse who was observed to be in the act of adultery, or when a spouse kills the paramour who is observed to be committing an act of adultery with the defendant's spouse, right? That can be mitigated to manslaughter. So why would we allow the government to re-elevate, or should I say elevate, that offense back to murder? All right, that seems to be a perverse outcome, an unwanted outcome. The legislature has clearly allowed for certain types of killing committed in the heat of passion to be mitigated from murder to manslaughter, and so we shouldn't allow the government to elevate that charge back to murder. All right, so notice what's happening here. Every felonious assault that results in death would constitute murder if there were no limitation on the application of the felony murder rule. And again, this does not seem to be what the legislature intended. All right, the legislature did not seem to intend for all homicidal assaults to constitute murder. Otherwise, they wouldn't have created the heat of passion manslaughter offense. So this is, in essence, why we have this independent felonious purpose or merger limitation. All right. In the Smith case, we have discussion of some earlier cases, Ireland, Wilson, and Sears. All right, a trilogy of domestic violence cases which involve homicidal assaults or homicidal violence, right? And in those cases, the court ruled that because the assault was factually integral to the homicide, and because the legislature intended these homicidal assaults to constitute a different offense, not murder, you can't deter those individuals, and so we do not allow the felony murder rule. All right, so in Ireland, the underlying predicate was assault with a deadly weapon. In Wilson, the underlying predicate was burglary or assault, an assault. And in Sears, the underlying felony was burglary, assault, but on a different victim than the family member. So in those particular offenses, right, there is no separate purpose for committing the conduct. And so they merge into the felony murder charge, and we cannot allow a felony murder charge. All right, so this is complicated. It's a odd doctrine. It's a confusing doctrine to get your head around. So take a look at the next slide. So this Venn diagram might help. Okay, so on your left, as you're looking at the Venn diagram that says merger, no felony murder charge, right? When the felony mergers into the homicide, when the point of committing the felony is essentially to engage in homicidal assault, there is no distinction between the two offenses. So assault with a deadly weapon, burglary with intent to commit assault, felony discharge of a firearm at an inhabited dwelling, right? Those felonies merge into the homicide, and no separate felony murder charge can be maintained. All right, if you look at the Venn diagrams on your right, you see that the felony charge does not merge into the homicide charge, and so a felony murder charge can be maintained. So, for example, furnishing drugs to another individual and that individual dies. Driving under the influence of drugs that results in a homicide. Poisoning an individual and death results. Committing armed robbery and a death results. Kidnapping an individual and the death results. Child abuse by malnutrition and dehydration, what we would call neglect. None of these charges merge into the homicide, right? The purpose or the goal of those felonies is not homicidal assault or killing an individual. We would say that those felonies have an independent felonious purpose. And so a felony murder charge can be predicated on these particular felonies. And if you're questioning me and wondering, okay, well, in particular, what about armed robbery? You have to understand that robbery has been interpreted to be a crime whose purpose is to obtain an item or money. The purpose is not to kill, even though a weapon or some physical violence might be used. All right, so in this particular case, felony child abuse merges, right? Felony child abuse, physical abuse, as distinct from neglect, failure to care for your child. All right, felony child abuse merges, and so you may not use the felony murder rule. And the way we determine this is by looking to the elements of the offense, all right? That there is some element that requires an intention to cause death or a serious harm or an intention to assault an individual. And so therefore there is no separate or independent felonious purpose between child abuse and the homicide. And so the child abuse merges in and a felony murder charge cannot be maintained. All right, so that's all we're going to talk about, the independent felonious purpose or the merger rule. This is definitely a difficult concept to understand. I'll have a little problem at the end which can help us tackle this, but that's what we're going to talk about for now. And we'll come back to it in a moment. Okay, next slide. So how does the Model Penal Code deal with the traditional common law felony murder or the more modern statutory approach to felony murder? Well, the Model Penal Code rejects this notion of felony murder, right? Under Model Penal Code 210.21b, right? We know, though, that you may have a homicide charge, the killing of another individual, that is committed recklessly under circumstances manifesting an extreme indifference to the value of human life. This is the Model Penal Code's version of or analog of felony murder, but it's somewhat different. It is not as stringent and is not as broad-reaching as felony murder, and it does require some additional effort on the part of the government to sustain the charge. So first, right, unlike the traditional common law approach, the Model Penal Code's murder under circumstances manifesting extreme indifference to the value of human life does impose a culpability requirement, right? It requires the defendant act recklessly. Remember, under common law, it is strict liability with respect to the death, but under the Model Penal Code, the defendant must act recklessly. Second, the Model Penal Code does set up a presumption. Recklessness and indifference can be presumed if the individual is committing or in the act of flight after committing one of certain enumerated offenses in the Model Penal Code. All right, so the Model Penal Code does require proof of some culpability, that is acting recklessly, but it does allow for a presumption of this recklessness and this indifference if the individual is committing or is engaged in a flight after committing one of certain enumerated offenses. The third difference from the common law is that the government must prove that the circumstances manifest an extreme indifference to the value of human life. So this is an additional element that the government must prove. Some important points to keep in mind about Model Penal Code 210.21b. The government doesn't have to rely on the presumption It could prove that the defendant acted recklessly, and it could prove, based on the facts, that the defendant manifested extreme indifference. The government may rely on the presumption, but it does not need to. But in any event, both elements must be proven, either with or without the presumption. Another important point to keep in mind is that if the government is able to produce enough evidence to rely on the presumption, it must consider the fact that the defendant may overcome that presumption. All right, so the government in its case in chief might prove that the defendant acted recklessly and with circumstances manifesting an extreme indifference to the value of human life. The defendant, either through cross-examination or through its case in chief, can try and rebut that. And if it does, then the government bears the ultimate burden to prove that the defendant acted recklessly and with circumstances manifesting an extreme indifference to the value of human life. All right, so the government ultimately bears the burden on both of those elements. Finally, one last thing to keep in mind is that if the government does satisfy the presumption, the jury does not have to accept the presumption. If the government produces sufficient evidence to find a presumption that the defendant acted recklessly and with circumstances manifesting an extreme indifference to the value of human life, this is a permissive presumption that the jury can choose to rely upon or can choose to reject. All right, so let's take a step back for a moment and on your own, think about how you might analyze the Fuller case, our auto burglary case and getaway chase case under Model Penal Code 210.21b and consider whether or not you can attach the presumption. Consider what would happen if you cannot attach the presumption or if you decided to proceed without attaching the presumption. Could you prove that the defendant acted recklessly under circumstances manifesting the extreme indifference to the value of human life? And once you consider the prosecution's case, consider the defendant's case. What arguments could the defendant offer to rebut? So post your thoughts on TWEN in the appropriate discussion forum, and we will work through those together. All right, next slide. We have another problem for you to consider on your own time, and then post thoughts on the discussion forum, and we can work through those. And this next problem is a case involving Sean Taylor, who was an NFL professional football player, and he was shot and killed in his home during a home invasion. And apparently the defendants thought that Taylor kept thousands of dollars in cash in his home, and so they were going to break and enter into his home and steal the cash. They had apparently planned to do this when they thought he would be at an away game. In other words, he would not be home because he would be out of town playing a football game. Turns out he was home because he had had a knee injury, so he was not playing in the game. And when they broke in, Taylor heard this and he got up and he wanted to protect his family, and he had a machete in the house, right? So he had a large knife, and he confronted the men who were near his bedroom door. And one of the men fired a shot, hitting him in the femoral artery, so a major artery in his thigh. And as a result, Taylor quickly bled out. All right. And so the question is whether or not, if you're the government, you could prove a felony murder charge, or whether, if you were in a Model Penal Code jurisdiction, you could prove Model Penal Code 210.21b. All right. And there were 5 different suspects who were arrested who were in on this attempt to rob or burgle Taylor's house. And so consider whether felony murder can attach to any or all or just some of those defendants. Only one of them had a weapon, and only one of them fired the shot that hit Taylor and ultimately resulted in his death. So could all of them be charged with felony murder? Think about that on your own time, and let's work through it on the discussion forum on TWEN. And then one last problem. So we've already looked at a vehicular heat stroke problem when we talked about unintentional killings. All right, here is one actually out of the Atlanta metro area. You might recall this. This is the so-called Atlanta hot car case. This happened about a handful of years ago. The defendant was Justin Ross Harris, who's pictured in your top right of the slide. And the facts are set out here, right? One day, right, he was supposed to be taking his son to daycare. On his way to the office, they stopped off at Chick-fil-A, right? Dad gets back in the car, continues his commute, and goes directly to work, parks the car, gets out of the car, and goes into the office building, right? He didn't take his son to daycare. His son is pictured also in the slide. Instead, his son sat in the car for 7 hours. It was a hot day. And the child ultimately dies due to hyperthermia, right? An elevated temperature in the car, an elevated temperature in the body, and complications from that. So the government was planning to charge the father with child endangerment and child cruelty. And so consider whether or not the government could also charge the defendant with felony murder or the Model Penal Code equivalent. And again, let's work through these on the TWEN forum, and I'll have some thoughts too. Okay, so that ends my discussion of felony murder. I know that some of that is quite complex and difficult to understand. Please take your time, work through the reading materials again, work through these slides again, try these problems. They will really help you unpack the application of the felony murder rule and some of the limitations on the felony murder rule.